Hi there, and welcome to another episode of Chat HOD. I'm Nick Hoffman, Global Head of Disputes at Harneys, and I'm delighted to be joined this time around by Jess Williams and Ben Hobden, who run our disputes practice here in the Cayman Islands. Jess, Ben, welcome. All right, let's jump straight into it. Jess, you've recently finished a long-running trial before the Grand Court. I think listeners would be interested to understand what the experience exemplified about the way we work at Harneys and the characteristics of cross-border work in the Cayman Islands.
Thanks, Nick. Yeah, we've been very fortunate to have a very busy last 8 months with very interesting cases, which have been bookended by two large trials. So one of them was mine, but the earlier trial started in February. That was a 4-week trial in the matter of Cayman Corporation, which is a technology company with operations in the PRC. 2 points are really highlighted to me in relation to both trials. The first was the seamless way that we work between our various offices, culminating in trial. In this case for Cayman, the Cayman and the Shanghai offices, and for Centra, the Hong Kong and the Cayman offices. On these cases, we've worked together with our colleague for years, and it's providing around-the-clock service to our clients, and it was really great to be able to come together as one team and present our cases to the court. It was also really helpful generally for colleagues who usually correspond by email and phone to work side by side and bond throughout the trial process, and it really strengthened our already strong teams. Just one other point I wanted to add in relation to your question, which really struck me during the trial, was the ability of our courts and the judicial administration to accommodate such large trials. I think this was particularly striking to me during Centra, as there was another very large trial being held at exactly the same time, both adding a large number of additional court users, and the judicial administration staff was just so accommodating and ensuring that we had the appropriate courtroom size available, ancillary rooms provided for teams, witnesses, opus and others. We were in courtroom 9. I don't know if either of you have had a trial in there yet, but it's a new courtroom in the judicial campus on Cardinal Avenue. Everyone was really impressed and comfortable with our setup, and we had a really large number of additional rooms to use during breaks and for other court users. Also, the ability for the court to service a paperless trial with electronic bundles. I still really hold on to paper, but I've never seen so little paper in a trial before, and the process was really seamless.
And I think just that ability to weave modern facilities with the old need for complicated and comprehensive trial processes is a real feature in the Cayman Islands now, and one that won't necessarily strike everyone listening to this as obvious. But as you said, the court's ability to accommodate complex matters side by side, simultaneously being heard, is a real feature of the modern Cayman court process. Ben, coming to you, and perhaps moving away from the sort of process itself, like Jess, I should say, you've worked in Cayman for well over a decade now, and you've seen the landscape change and meander over that time. What types of disputes are clogging up your inbox in 2025?
It remains a mixed bag. That the market has certainly seen a quieter period as it relates to insolvency, though interestingly, it does appear that over the last few weeks, there seems to have been a little bit of an uptick there. One of the real changes or new work streams that we have seen recently is disputes within an exempted limited partnership, particularly at the end of its life. The court has seen any number of relatively high-profile disputes where a partnership has reached the end of its life and is in a wind-down process, and there is a dispute between the incumbent general partner and the limited partners as to who is best placed to run the wind down process. And it's particularly of interest because many limited partnership agreements are quite restrictive in terms as to how and when a general partner can be replaced. But in a number of cases, 1001 Voices, we have seen SenseGain, Malaysian Venture Capital Management, there has been a dispute before the court, and the court has now found that when a partnership is in a wind down process, the will of the limited partners will effectively override any restrictive provisions in the limited partnership agreement, and the court will order that a professional liquidator can wind down a partnership if that is what is wanted by the limited partners. That has recently been considered by the Court of Appeal in 1001 Voices, who have approved the approach of the first instance judges. So we can assume that that is now relatively settled law.
Yeah, that's perhaps not a unique development so far as the offshore world is concerned, but an important one to have embedded in the case law, giving, I think, limited partners and indeed GPs more certainty as to how the courts are likely to deal with these agreements and disputes arising out of them. And as you say, these things ebb and flow, and they have done throughout the last decade, where certain types of disputes become more and more part of the landscape at any one particular period. But one area that appears to have endured, Jess, and you referred to it earlier through the prism of the Cena trial, is appraisal actions or share valuation actions. To the uninitiated, what's involved in those cases and why do you think they've endured?
We've been involved in these cases for a very long time. As I mentioned, we're one of the lead firms acting company side. They essentially involve companies which are usually listed on US exchanges, but not always. But they have their holdcos in the Cayman Islands, and usually have their operations in PRC, essentially going private. And the mechanism in our legislation allows shareholders to dissent and come to the Cayman court, essentially for assessment of what is the fair value of their shares at the point of time of the merger. They have been going on for a long time, perhaps longer than some commentators have expected. And I guess it's not just limited to the Cayman Islands. We've also seen an increase in the jurisdiction in Bermuda, for example. And there's a recent decision from the Privy Council, which is very interesting, in the Jardine proceedings in Bermuda, which has a number of interesting aspects which we've written on.
It's been an enduring part of my practice and indeed the Cayman practice and Harneys practice as a result more widely. I think there are a couple of aspects that have ensured that dissenters are still interested in what the Cayman courts have to say about the value of their shares in these particular contexts. I guess in the end, it comes down to those central pillars that we have, the cost shifting aspect, the ability for dissenters to obtain an interim payment, and the willingness of the courts to consider how those shares have been valued by the company and the various methodologies that are involved.
It's interesting, Jess, that in the context of appraisal actions, you mentioned Jardine. Obviously, all of us will have seen significant literature on the abolition of the shareholder rule. And
Yes.
It does seem to have been somewhat overlooked that this was in the context of dissenting shareholder litigation in Bermuda.
Yeah, and it's understandable why it might have come up. To really the last aspect of what I want to discuss with you both, and again, something that you and I have seen quite a lot of over the last few years, and that's the China property restructuring boom. Obviously, these cases have made a fairly big splash worldwide, from the most well-known in Evergrande to Kaiser and others. What are you seeing in respect of that at the moment?
At the moment, a little bit of a slowdown, Nick. As you mentioned, the last few years has seen significant cases coming through the Cayman courts, sparked by the default of Evergrande in 2021. We have acted on any number of those big ticket restructurings. We had a significant role in Evergrande. We've acted company side in Kaiser and Yuzhou, for example. But following, and perhaps this has led to the slowdown, following the liquidation of Evergrande in Hong Kong, we at the moment are seeing less new restructuring mandates for the property developers. Now, perhaps that is simply because they have restructured in the last 12, 24 months, currently are actually able to service that newly negotiated, newly schemed debt. And it may well be a wait and see as to whether or not they continue to be able to service that, or whether they will need to come back to court in Cayman to propose another scheme of arrangement to avoid them going into any sort of insolvency process, be it here or in Hong Kong.
Yeah, I think that's probably right, Ben, and we'll have to wait and see how the macroeconomic environment likely affects the desire or the necessity of some of those China property cases to fulfill those restructurings, or maybe come into second and third round. Well, that brings us to the end of this episode. I just wanted to thank both you, Jess and Ben, putting me through a whistle-stop tour of the Cayman landscape, and hope to see you again soon.